Hello, and welcome to the Orange County Bar Association's Community Legal Project on today's topic, Trust for Children and Pets. My name is Faye Pappas, and I'm a personal injury attorney practicing in the fields of wrongful death, medical malpractice, and car accidents here at the law firm of Bailey Fisher in Winter Park, Florida. But enough about me. I'm here to introduce our speaker today, an expert in estates and trusts, attorney Ashley Winship. Ashley Winship has practiced in estates, business, and tax since 2004 and is the president of Winship Law PA, which she established in 2014. Ashley is passionate about planning, which makes her clients' lives inherently easier with her processes. Through her extensive knowledge, she helps families with smooth transfers of assets to future generations. She also helps with anticipating and planning for major life events such as marriages, divorces, births, incapacities, and end-of-life decisions. These major life events and occurrences are instances that call for a plan. And Ashley is here to help. With over 15 years of experience, she advises clients about strategies for transferring assets while minimizing taxes and creditor exposure. Throughout the process, Ashley focuses on reducing worry for her clients and providing security for their loved ones. To learn more about Ashley and how she can help you with these, please go to www.winship-law.com. So Ashley, take it away.
Well, thank you, Faye. Thanks to the OCBA and CFAL for inviting me here. Today's talk, Trust for Kids and Pets, is really for parents, grandparents, any adult that has kids in their life. And when I talk about kids, I'm talking about kids of all ages. Of course, having a trust in place for a minor child is important because if the minor child inherits assets in their individual name, that will then require that an adult in their life petition the court for legal guardianship of their property. Once a legal guardianship is established, then that adult must keep the funds in a restricted depository account that can only be accessed with a court order. And once the child turns 18, those funds are turned over directly to the child. With so many kids that turn 18 while still in high school, that can be just a terrible outcome. And so having a trust in place to allow somebody to manage trust assets without court intervention and extend the period of time which that adult can manage assets for a kid is crucial. But trusts are not only established for minor children, they're established for adults too. Sometimes adult children need protection from themselves, from others, such as creditors or former spouses. There's also an element of tax planning that goes into establishing trusts for adults. And sometimes adult children are on government benefits such as Medicaid that require special trusts to be established for them to enable them to remain qualified to receive those benefits. Trusts in Florida can actually also be for our fur babies too, so we'll talk briefly about that today as well. So today I'm going to cover just very generally how a trust is formed, how you choose the trustee to be in charge of the trust, and some basic overviews of designing the trust and the distribution standards of the trust. So let's begin. So first of all, a trust for kids can be created during your lifetime, known as an inter vivos trust. If you create a trust for a kid during your lifetime, that would be in the form of a standalone trust agreement where you name a third party to serve as trustee, and those trusts are funded with lifetime gifts. A lifetime inter vivos irrevocable trust is usually established for the purpose of more typically, we're talking about establishing trusts for kids in your testamentary document, whether that's your last will and testament or your revocable trust, which becomes effective upon your death. When you establish a trust for a kid in your will, That trust is funded upon your death with assets that flow to probate pursuant to your will into a trust that's established under the will's terms. Alternatively, you may incorporate into your estate plan a revocable trust agreement, which is a type of trust that you establish during your lifetime, but stays in place for your benefit under your sole control, and then upon your death, revocable and fund a separate trust written under the trust agreement for your child. Once you determine where you're establishing the trust and what type of document you're using to establish the trust, the first thing you should think about is selecting the trustees for the trust. It's the trustee's job to manage and invest the trust assets, report to the IRS and pay taxes, account to the beneficiaries on how the assets are invested and managed, and distributing the trust assets pursuant to the terms that you provide in the trust agreement. You can name one or more trustee to serve together over the trust, and a trustee can either be an individual, such as a trusted family member or friend, a professional advisor like a CPA or an attorney, or it can also be a corporate entity, such as a bank or trust company. When you're thinking about selecting the trustee, it's also important to think about different scenarios and alternates to the trustee that you pick. When you set up this trust, typically you don't have a real clear picture of when the trust provisions may take effect, whether it's a year from now, 5 years from now, or 30 years from now. So designing your trustee provisions to account for the fact that they may need to step up at a certain time is equally as important as considering their skill set and the ability to complete the job. Another factor that parents or grandparents, adults consider when they're designing a trust for kids and selecting the trustee is what will the dynamic look like? How will the trustee handle the child beneficiary? Will they be sensitive to that child's needs, or will they be stern enough to handle a difficult child? Those are things to think about when you give somebody that job. And of course, always talk to that person about whether they would be willing to serve, so that if you pass away and they're called upon to serve, that they're not caught off guard, and also gives you the opportunity to consider other alternates if they seem a little unwilling to serve in that role. So when you're designing a kid's trust, I like to explain that there are two different architectures, generally speaking, that we're typically choosing from. The first one is not a technical term, but I like to call them birthday trusts. Birthday trusts, as I call them, are trusts that are set up for a child to protect them from themselves and their immaturity, but by the terms of the to fully distribute at a certain milestone at which you predict they will be mature enough to handle their inheritance. That milestone might be their 21st birthday all at once, with the belief that they will be ready once they are past typical college age to take their inheritance and manage it themselves. Or you stage it out, where you design it where 1/3 of the trust principal is released at age 21, half of what's left is released at age 25, and the remaining trust principal is distributed at age 30. In the alternative, some parents really like the idea of a dynasty trust. A dynasty trust is a trust that is where the assets remain in trust in the long term, where the trust does not ever expire just because a child hits a certain milestone or birthday. This is an approach that parents take when they are concerned about protecting an adult child from creditors, divorce, or taxes, where they're very concerned about keeping the trust assets in the family upon the death of that child and redistributing that among their grandchildren or other desired beneficiaries as opposed to their child's spouse, and also to prevent spousal influence over what that child does with their inheritance. One of the fears that a lot of my clients have is that upon receiving a distribution outright and free of trust, that their child will automatically commingle that asset or do something with it that their spouse thinks they should do, versus keeping it separate and doing what the child believes is the best thing to do with their inheritance. So a dynasty trust allows that to happen and provides some framework around those assets. Other reasons why parents may establish long-term trust is if a child has some particular issue that is expected to remain in the long term, such as addiction, spendthrift issues, or illness, whether mental or physical. Sometimes with dynasty trust, if we are not necessarily concerned with protecting the child from themselves, the person who sets up the trust may also pick an age at which the child could become their own trustee, but still subject to the provisions that you set up in the trust agreement. Once you pick your architecture, then you need to think about what are the distribution standards for the trust. Almost any trust that you will ever read will typically include a term or a standard that says that the trustee can benefit the beneficiary and make distributions to or on behalf of that beneficiary for their health, education, maintenance, and support. We call this the HEM standard, and without going into too much legal explanation, there are really important reasons why we use this standard. Number one, it's widely understood by folks who are administering trusts and interpreting trusts. There's lots of interpretive cases and other guidance in our laws regarding what this means. But really on a very basic level, the HEM standard allows the trustee to provide all of the basic needs that the average beneficiary will need to keep them happy, healthy, fed, sheltered. Health and education is just like it sounds, paying for medical expenses that aren't covered by insurance or other expenses that may be elective type medical treatments. Educational expenses would be things like tuition and other costs related to education. And maintenance and support is really our lifestyle type distributions and our standard of living type distributions, paying for rent or a mortgage payment, keeping food on the table and clothes on our back and a car to drive, and reasonable costs for entertainment and other comforts of life. When a trust is going to be a long-term trust, such as a dynasty trust, it's pretty popular with my clients to also allow the trustees to benefit their child's children, so my clients' grandchildren from the trust, as secondary beneficiaries. The idea there is that if the trust is going to be in place throughout the child's lifetime, that it is nice if there are needs for that child's children for college tuition or helping them with their first apartment or giving them an allowance, that those funds are available to benefit the child's children. Other terms that you sometimes see in trust include the ability for a trustee to make distributions for the child's best interest. This is really giving the trustee full discretion to make a distribution for a child for whatever they think is appropriate. If the trustee thinks it's appropriate and in the best interest of the child to pay for that child to travel and have a gap year between high school and college, that would be available. On the one hand, depending on who you pick as the trustee, you may be completely comfortable with that. Most of the time, my clients feel comfortable with the HEM standard and they don't want to spoil their kids, or they might feel uncomfortable with giving a third party so much discretion. But it is available and is appropriate in certain circumstances. You could also give the trustee the ability to make distributions for certain significant life events, such as graduation, paying a down payment for a first home, covering expenses for a wedding or for that of their child, or even startup capital to start their own business. This is a provision that many of my clients like. That is a special occasion type distribution that you could include in a child's trust. Sometimes my clients like to take the guesswork out of trust provisions and just allow the trust to automatically distribute all of the income earned on the trust principal to the beneficiary in certain increments, whether it be quarterly or annually or some other time increment. So this allows the trust assets to flow to the child and that they have a certain amount that they don't have to ask for. If you were using a dynasty trust structure, this type of provision is usually not used because it jeopardizes some of the protections that a dynasty trust provides as far as creditor protection, and also could have negative tax implications as well. Incentive provisions. Sometimes my clients come to me with things they have heard about where there's an income matching provision. For every dollar my child earns, I want the trust to give them another dollar. The idea being there that a child could select a career that is not necessarily 100% financially based, but could choose something that is traditionally lower paying, such as charitable work, teaching, other things that maybe aren't as lucrative, to allow them to maintain a certain lifestyle while doing honorable work, I guess, is one way of thinking about it. On the other hand, some studies have shown that incentive provisions actually disincentivize beneficiaries, surprisingly. Sometimes children take jobs that aren't at their highest potential because they're going to be paid with as though they're making twice the income. They may not be as motivated to study and find a more lucrative career because they can just sit back and collect dollar for dollar on their earnings doing something that is, less motivating. Finally, as mentioned earlier, special needs trust, neither birthday trust nor a dynasty trust would be an appropriate architecture for a child who is or will become eligible, and we expect them to be on government assistance, specifically Medicaid. And so there are special trust structures and distribution standards where the child's trust can be set up to provide supplemental needs, things that their government assistance doesn't cover. And those types of trusts allow the child to continue to qualify for their assistance while also enjoying some extra things in life that wouldn't necessarily be covered by those benefits. So of course, we also have our fur babies. So you can create a trust for your pet. My husband and I actually have a trust in our estate planning documents for our doggies. And in that trust, you can name who will be the caretaker and successor caretakers of your pets. Or you could list in a way that a process by which allowing somebody else to pick successor caretakers if the person nominated as the caretaker is unable to take them in. You could also name a separate trustee, separate from the caretaker, to manage the financial aspects and to provide distributions to the caretaker for the pet care. You could even charge the trustee with visiting the pet periodically to ensure that their living standards are up to their living conditions are up to your standards. Finally, in the pet trust, you can name who will become the beneficiary of any assets that are left over upon the death of the last pet, whether that is the caretaker and appreciation for them providing your pet with a loving home, other individuals such as friends or family, or even a charity such as a pet rescue organization for pets that need continued. Once you set up the trust and design the trust, it's also important to fund the trust. This is a diagram that I share with all of my clients in their initial consultation. It's important for people to realize that just because you put a trust on paper, you also have to do the subsequent work to align the assets to the trust. And so what this diagram shows us is that there are 4 different ways that our assets get to our survivors when we pass away. So we really need to be mindful of how those assets are structured once we set up the trust. Number 1, if you own an asset jointly with somebody with rights of survivorship, when you pass away, the other owner of that asset automatically becomes the owner of the asset without any restrictions of the trust that you have set up in your will or another trust agreement. So if you put your child's name on a bank account and you pass away, that account becomes 100% theirs with no rules. If you own assets in your individual name, they fall under either Category 2 or Category 3. Category 2 assets that have beneficiary designations, we call them non-probate assets, assets that don't require the probate court's use. Those assets pass pursuant to the paperwork you have on file with the financial institution. For example, transfer on death accounts at your bank, retirement accounts, life insurance policies, and certificates of deposit. When you establish that account, you are asked to designate a primary beneficiary and a contingent beneficiary. If you have named your child as the primary beneficiary, that asset will go to them upon your death in their individual name and not restricted by the trust provisions. If you individually own an asset that does not have a beneficiary designation, then it falls under Category 3, and we call these assets probate assets. Assets that are individually owned without a beneficiary designation, the way that they flow to your survivors is through the court process called probate. And when you pass away, the person named in your will petitions the court for permission to control and dispose of your assets. Until the court appoints that person or representative, the asset cannot be accessed, it cannot be transferred. Sometimes people, when they first meet with me, think, I want to have a will to prevent probate. And actually what I think this diagram really shows us is that the will only controls the assets that go through probate. So it's actually an opposite of what a lot of people I find perceive a will to do. It is actually the instruction manual to probate. Examples of assets that go through probate are stocks that have your individual name on it or brokerage accounts without a beneficiary designation, real estate and titled personal property such as cars, boats, motorcycles, and trailers. The last way that our assets get to our survivors is by using a trust. Specifically in this diagram is meant to reference a revocable living trust. A revocable living trust is an agreement that you set up where I like to think of it as creating a bucket that you can put your individually owned assets in so that they don't have to go through probate. It is, while you are living, it is fully accessible by you. I like to tell my clients, if you set up a revocable trust, you're the boss. It has an instruction manual, but you aren't necessarily bound by the restrictions and the duties and responsibilities listed in that trust. You can do whatever you want with those trust assets, and it uses your Social Security number during your lifetime, so there's no separate tax filing requirement. So for folks who are interested in preventing the hassle, the expense, the delay that, well, not the end of the world, probate may cause, then most of my clients opt to form a revocable trust as their will substitute. And then once the trust is established, we help them fund the trust by looking at their non-probate assets in Category 2 and determining which assets should be named the trust as the primary or contingent beneficiary. We help them move assets out of Category 3 to legally title them in the name of their trust. And then we still do a will, but the will is in the form of what's called a pour-over will, which simply means that if an asset is inadvertently excluded from your trust and you pass away, that asset will find its way to the trust with the trust being the beneficiary of your probate estate under your will. So this is a really important thing to know, that paperwork is just paperwork. When you do estate planning, the funding is really the important part of it once you have your paperwork in place. A couple other quick words of caution. Please don't do it yourself. Make sure that you find an experienced attorney to help you. There are laws in the state of Florida that are specific to what we can do with our homestead upon our death. There's actually restrictions on who you can leave your homestead to and what happens if you don't. There's also elements of creditor protection when you design your estate plan in a way to flow to protected heirs. There's also landmines out there, such as the spousal elective share. In Florida, we cannot disinherit our spouse, so you need to work with a professional that understands what the laws are there so that you don't inadvertently trigger a lawsuit after your death. If you wrote your estate planning documents before getting married or before having children, we have laws that override certain aspects of your estate plan. We call them pretermitted spouses or children. There are tax considerations in the funding, income tax and estate tax alike, and also special issues related to assets such as S corporation stock and retirement benefits. So once you've thought through a lot of these concepts, be sure to reach out to an experienced estate planning attorney to help you so that you don't have things go sideways upon your death. And it's always heartbreaking to see what people intended to do with their estate plan, but for one reason or another, some of these landmines interact in a way that causes their assets to go in a different direction. So if any of you have any interest in talking about your specific circumstances, here is my contact information. Please feel free to reach out to a member of my team to schedule an appointment. And again, I thank you, Faye, the OCBA, and CFAL for giving me the opportunity to talk about something that I am clearly very passionate about, which is helping your family and planning for kids and pets.
All right, thank you so much, Ashley. And again, folks, if you'd like to learn more about Ashley or perhaps pose your own questions to her directly, go to www.winship-law.com. Thank you so much, and thank you for joining us today.